Mr. Todd Vandermine, NRA's Illinois lobbyist. Todd, thank you, sir, for coming on the program tonight.
Not a problem, Cam. Always good to be with you guys.
Well, it's great to have you here. And today, a big day in Illinois. Tell us what was going on. This was a hearing on one of the challenges to Illinois' lack of any sort of carry law, right?
True. There are two suits that are filed in federal court. One is Moore v. Madigan, which was the one that was heard today. That suit was brought by the Second Amendment Foundation, Illinois Carry, and some individuals. The suit that we are involved in is Shepard v. Madigan, which was filed in the Southern District Court. And so today, the judge had scheduled a hearing on the motion for a preliminary injunction against the enforcement of the UUW and the aggravated UUW statutes, which are the statutes that prevent somebody from carrying a gun for self-defense in public.
What does UUW stand for?
Unlawful use of a weapon.
Simply carrying a firearm for personal protection would be unlawful use of a weapon in Illinois under Illinois law.
That's how it's defined.
Okay.
Yes. So it was real interesting, the lawyers for Mr. Moore and the other plaintiffs put on their case in the beginning, and the state responded, and the state stuck to what they'd put in their briefs. And what was, interesting was they had a two-part approach to it. The first part was that the Second Amendment should be capped circa 1791, and it should be looked at only in that time frame. And they tried to go back to arguments of English common law that, average people weren't allowed to carry guns, and it was not uncommon to have, bans of carrying of weapons and the such. But, if you take their argument at face value, then, we're celebrating the centennial of the 1911, are we not?
Yeah.
So John Moses Browning's design, which is over 100 years old, would get less protection under the Second Amendment than the Internet, which you and I have seen come about in our lifetime.
Yeah. Yeah.
The Internet's 25 years old.
Yeah.
And under the First Amendment, it enjoys much more protection than they would argue as to what a 1911 would, taking their logic. So they went down that road. They had a relatively young guy making the arguments about, how this should be viewed. They tried to gloss over the 19th century case law that dealt with carrying of guns and tried to take everything back to prior to the adoption of the 14th Amendment, which was, interesting to see how they wanted to kind of pick and choose what they were willing to cite for case law. Beyond that, the state then made their arguments about why a preliminary injunction was not warranted and trying to make procedural arguments, but then they went into this whole thing about a Brandeis style. They wanted to introduce some studies that they had cited into evidence and the social costs of carrying guns and how this was going to be just a huge burden on the state at large, that people would be getting shot and killed. And they went into this whole, causation, social experiment, and it's just like the Supreme Court dealt with that.
Mm-hmm.
Because, they in how they explicitly said, we're not going to deal with an interest balancing approach to this.
Right.
The judge who had run for the state Supreme Court as a Democrat and had been supported by such notaries as Dick Durbin, came out and he said, well, when I transport my gun, I've had it in a case, broken down, and in the trunk, and took everybody by surprise that they sat there and she threw this out there and talked about. And it was almost as if she was going to Peruta, and she brought up the Peruta case as to whether or not she's trying to find something there. She was very interested in what the pro-gun arguments were as far as standard of review, how to look at it. The state had a big job today. The state had to argue two things. Since we've had the Uzell decision, the state had to argue that this was not a prohibition, that this was a regulation, and they had to argue that it didn't affect the core right. And they tried to do both of those. They were feeble, in my book, and their lawyers didn't do a very good job of the arguments at hand that they had. But that's what they attempted to try to do. The judge was really searching and trying to get a handle on how, what standard of review to look at, how to look at this. And so it was quite interesting and quite refreshing to sit there and see a judge really, there's not a lot of settled law in certain areas of this, but I think Heller is very controlling. McDonald certainly is, and Ezell now is.
Yeah.
So it was a decent day. And one thing that, the guys that were in the courtroom said about got whiplash because the AG's lawyer went up there and he started going off into some tangent about, whether or not there would be Commerce Clause issues, but then no guns are made here in the state of Illinois. And I'm like, you don't understand that we have 65 firearms manufacturers in the state of Illinois?
Right.
I mean, you've never heard of Springfield Armory, Rock River Arms, amongst a few others?
I suppose it's possible that they've not.
So that part was kind of, almost comical. But it was, and the rebuttal to the state's arguments went very well, I thought. They teed up that, this was a prohibition, that there was no regulation involved. We weren't talking about time, place, and manner restrictions. We were talking about you can't do this. And so, it was an interesting day. Believe it or not, there were several members of the media that came down to watch this. It started to hit the newspaper sheets about what's going on, and that these challenges are starting to move. And on her way out the door, the judge indicated that she would probably not be able to have a ruling rendered by tomorrow, but that she would be working to get one done quickly.
Oh, wow. I mean, that's interesting. I mean, not going to be tomorrow, but soon then.
Yes, that's what she's saying now. So I would say that next week is a very likely possibility for us to see movement in either one or both of these cases. I would also, it's going to be interesting to see how the judge. She certainly wasn't hostile to our position, but she was trying to find, where her legs were on this as to what the issues were from. She was read up on Heller. She was read up on Ezell. Made some comments about Ezell. So we'll see. Either way, it's going up on appeal. In either case, between Shepard or Moore, because if we win an injunction, the state's going to take it up on appeal. And if we lose the injunction, we're taking it up on appeal.
Yeah.
So we're going up the legal chain just as fast as we can. And it's, it's going to be a fight. But after what the Ezell court did in setting down their new two-part test and their review of Second Amendment litigation, it's going to be interesting because just a week ago, I sat in a courtroom when there was a hearing on the Chicago gun shop ban. And that judge there was very specific about how controlling Ezell was. And in light of that, he brought up to the city's lawyers that when an appellate court says you thumbed your nose at a Supreme Court decision, you should pay attention to that.
Oh, really?
Oh, yeah. He was very explicit about it, and he even reminded them of what Judge Easterbrook said in the Fees case when, the city said, there's no final declaration, they didn't prevail, we changed the ordinance. And the judge told them that, no, Judge Easterbrook said they went to the Supreme Court and they won. So I think that he was hinting to them that if you're going to change your ordinance, you have a window of opportunity to do this, because once we get too far down this road, you're not going to weasel out of it like you tried to do in McDonald. Mm-hmm. So I think that it's real interesting here. We've got these cases going. We just filed amici briefs in the Wilson case, which is the challenge to the Cook County semi-auto ban. We've got another Supreme Court case picked up on a UUW again, a challenge to that statute that's gone up on a criminal case that we'll be filing briefs in. And we have a host of other lawsuits pending over Chicago ordinances and other stuff.
Right. Wow. All right. Well, listen, Todd, sounds like it'll be a calm weekend, but it could be some excitement in the next few days. So look forward to talking to you probably next week, sir.
Probably. It's going to be interesting to see how this judge deals with it. And, what would really be kind of ironic is if we got a split decision within the district courts to where one said yes and one said no to the injunction.
Yeah. Oh, yeah. Well, yeah. That and again, given the fact that this is going to be appealed regardless, a split, may have the, I guess, the impact of speeding along the appeals process.
It may. The state was just absolutely convinced that if there was an injunction issue, that mayhem would break out immediately. And, the lawyers said, wait a minute. That's what D.C. said. Didn't happen. Chicago said that, and 4 days later enacted a new ordinance. No mayhem broke out anywhere.
Mm-hmm.
And cited some of those things. So I saw the state grasping for whatever straw they could. I think if Regis had been there and they could have phoned a friend or called for a lifeline, they would have.
Well, I'm kind of glad that option was off the table for him. Hey, Todd, thank you so much, sir, and you have a good weekend. Look forward to talking to you again very soon.
Well, take care, Cam.
All right, thanks, sir. Todd Vandermyde, NRA's Illinois lobbyist, with us here on the program.